Dear students, welcome to MOOC on Human Rights in India. In this module, we take up the Protection of Human Rights Act 1993. In this module, we will look at three things: the historical context in which the Protection of Human Rights Act was adopted and enacted. Secondly, we will also see the provisions of the Human Rights Act, and we will also see how they comply with the Paris Principles. First, the historical context. The UNESCO first mooted the idea of a national commission for the protection and promotion of human rights, but it did not catch much steam. In 70s, this idea was again revived, but eventually in the early 90s, there was an international conference on the issue of national mechanisms for the protection and promotion of human rights that was held in Paris, which adopted the Paris Principles. And subsequently, these were adopted by the UN Commission on Human Rights and also by the UN General Assembly. So this adoption of the Paris Principles gave a further fillip to the establishment of national human rights commissions. And if you look at the Indian context, there were international calls for accountability for human rights violations in Jammu and Kashmir, in the Northeast, in Andhra Pradesh, and not only international outcries, but also there were aspirations from the civil society within India for establishment of a mechanism for better protection of human rights. And that's how in the month of September 1993, an ordinance was passed by the Government of India establishing a National Human Rights Commission with Justice Ranganath Mishra as the chair. Subsequently, a legislation was introduced in the Lok Sabha and that was passed, and that's how the Protection of Human Rights Act 1993 was adopted by India. Now let us look at the various features of this act. The preamble of this legislation captures the spirit. If you look at the preamble, there is a reference to the establishment of a national human rights commission at the union level, and also state human rights commissions in various states and human rights courts for quote unquote better protection of human rights. So prior to this 1993 Protection of Human Rights Act, the Supreme Court, the High Courts had been custodians of human rights, had been jealously guarding human rights. A need was felt for establishment of a special mechanisms for better protection of human rights as captured in the preamble to this act. Definition of human rights is an extremely important element, which is given in the section 2D. Section 2D defines human rights as right to life, right to liberty, right to equality, and right to dignity, which are guaranteed by the Constitution of India or embodied in the international covenants and enforceable in Indian courts. Section 2F of the Protection of Human Rights Act further defines these international covenants as the International Covenant on Civil and Political Rights 1966, the International Covenant on Economic, Social and Cultural Rights 1966, and such other conventions which are adopted by the UN General Assembly and which are specified by the Government of India in a gazette. So this is how the human rights have been defined in the Protection of Human Rights Act in both section 2D read along with section 2F of the Protection of Human Rights Act. Chapter 2 of the Protection of Human Rights Act talks about the National Human Rights Commission. In particular, if you see the section 3.2, it talks about the NHRC that it shall consist of a chairperson, 2 members from higher judiciary and 3 members from people who have expert knowledge and experience in matters relating to human rights. According to section 3(2), there shall be a chairperson who has been the Chief Justice or a judge of a Supreme Court of India, and 1 member shall be a judge of the Supreme Court, and 1 member shall be a former Chief Justice of the High Court, and 3 members of whom at least 1 shall be a woman from those who have special knowledge or experience in matters relating to human rights. Thus, the commission shall consist of 6 members, 3 drawn from the higher judiciary and 3 from those who have special knowledge and experience in human rights. In addition, section 3, subclause 3 of the Protection of Human Rights Act talks about 7 deemed members. For instance, the chairperson of the National Commission for Minorities, National Commission for Women, Scheduled Castes, Scheduled Tribes, Backward Classes, the Commission for Protection of Child Rights, and also the Chief Commissioner for Persons with Disabilities shall be deemed members of the National Human Rights Commission for carrying out functions which are specified in section 12B to J of the Protection of Human Rights Act. We will see shortly what is this section 12. Section 12 basically defines the functions of the National Human Rights Commission, and according to section 3(3) of the Act, the deemed members shall have a role in all functions of the NHRC except the one dealing with handling individual complaints of human rights violations. And as far as the individual complaints of human rights violations are concerned, the 6 main members or the main commission shall alone have the competence to handle these complaints. Now, let us see the section 4 of the Protection of Human Rights Act, which talks about the appointment of a chairperson. In fact, the chairperson and members are appointed by a high-level body of 6 members headed by the Prime Minister of India, and the composition of this high-level committee includes the Speaker of the Lok Sabha, the Deputy Chairperson of the Rajya Sabha, and also leaders of opposition from both the houses, and also the Home Minister. So in a way, the composition is a very high level one, and the presence of the leaders of opposition in this committee is a kind of an assurance that only people with high integrity, high credibility get selected for appointment as chairperson and members. Section 6 of the Protection of Human Rights Act talks about the tenure of these chairperson and members. According to it, the chairperson shall have a tenure of 3 years, or he can go up to the age of 70 years, and the chairperson is also eligible for reappointment for a further term. On the other hand, the members are appointed for a term of 3 years, and they have no chance for getting reappointed for the second term. In addition to the things that we have seen earlier on, the Protection of Human Rights Act also specifies the manner of removal of chairperson and members. They could either resign or can be removed after a proper inquiry for proven misbehavior or incapacity. If you look at the following graphic, it clearly tells on the various grounds for the removal of chairperson and members. These are more or less on the lines of similar provisions for the removal of judges of the Supreme Court of India. Section 12 of the Protection of Human Rights Act gives the functions of the Commission. In fact, there are many functions of the Commission, starting with individual complaints. In fact, the Commission has the power to take up complaints about human rights violations. These complaints can be of two kinds. One, acts of commission or omission by a public servant, and it can be either brought by a petition from the affected individual or suo motu cognizance based on newspaper reports, or it can be triggered by a referral from a court of law. The Commission also has a power to intervene in a pending proceeding in a court of law which involves substantive dimensions of human rights. The Commission can also visit jails and other such institutions where persons are kept for reformation or other purposes, and make recommendations for better living conditions and protection of human rights in these institutions. The Commission can also review the safeguards that are provided in Constitution of India and other laws that have been adopted by the Parliament, and suggest recommendations for better protection of human rights. The Commission can also undertake and promote research, spread human rights literacy and awareness, and promote the activities of non-governmental organizations. The Commission has a statutory responsibility to monitor international human rights conventions and make recommendations thereon. Section 12 of the Protection of Human Rights Act also requires the Commission to study factors which impede the enjoyment of human rights, say for instance terrorism or poverty or any such factors. The Commission is supposed to work on multiple legs, walk on many legs, both protection as well as promotion. If you see the following graphic, it brings out very clearly the various functions of the National Human Rights Commission. In order to discharge these functions, the Section 13 of the Act stipulates that it will have the powers of a civil court. It can summon people, ask for any documents, ask for witnesses to depose before it, and Section 14 enables the NHRC to utilize the services of any investigative agencies that is in position. Section 17 of the Act talks about the procedure for dealing with inquiry into complaints. The moment a complaint comes, the Commission may ask for a report, and if it is satisfied with the report of the concerned state government or the central government, it may either accept it, or if it is not satisfied, it can conduct an inquiry. And Section 18 of the Protection of Human Rights Act talks about steps after inquiry. After finding a prima facie violation of human rights, the Commission could either recommend the payment of compensation to a victim. It can also recommend prosecution of the guilty personnel who have committed the violation of human rights, and it can also make other orders. The Commission also has the power to approach the Supreme Court or High Court for issue of appropriate writs, orders for enforcement of its recommendations. One interesting thing about the National Human Rights Commission is that it has the power to award interim relief even pending the conclusion of a particular inquiry, if it is satisfied that the circumstances merit the award of a interim relief to a victim. Section 19 of the Protection of Human Rights Act stipulates the procedure for dealing with complaints of human rights violations committed by armed forces personnel. Here, the Commission can seek a report from the relevant authority, that is in the case central government, the Ministry of Defence, and after receiving the report, the Commission can make its own finding. There is one important distinction between human rights violations committed by public servants in general and the acts committed by armed forces personnel. With regard to the violations committed by personnel of armed forces, a separate procedure has been mentioned in the Protection of Human Rights Act. The Commission cannot investigate the violations committed by the personnel of armed forces, and this issue has been critiqued by many civil society groups. Section 20 talks about submission of annual reports or special reports by the National Human Rights Commission. One interesting thing here is that the government is required or mandated by the Protection of Human Rights Act to submit a memorandum on the action taken on the recommendations of the National Human Rights Commission. In case it is not accepting any particular recommendation, the government is required to spell out the reasons for non-acceptance of the recommendations, and this document is required to be laid on the table of the Parliament. So this in a way serves accountability. It holds the executive accountable for protection and promotion of human rights. Section 21 deals with the state human rights commissions, and the state human rights commissions have more or less the same functions as the National Human Rights Commission, but the one important distinction is that if you look at the list 2 and list 3 in the 7th schedule of the Constitution, which basically deal with the state list and concurrent list, the SHRCs have a mandate over the items which are mentioned in the state list or in the concurrent list. The chairperson of the commission can be appointed by a high-level committee, and he can hold an office for a year or 3-year term and is eligible for reappointment. And the chairperson has to be a former chief justice or a judge of a high court, and the state human rights commissions are supposed to be a 3-member body with 1 chairperson and 1 member who has been a judge of the high court and 1 member who has a practical experience in the matters relating to human rights. Section 30 of the Protection of Human Rights talks about human rights court, that it enables state governments to specify a sessions court in every district to try violations of human rights in the human rights court. Does the NHRC, which has been established under the Protection of Human Rights Act 1993, comply with the Paris Principles? We have seen in the earlier module these Paris Principles, how they talk about wide mandate, how they talk about autonomy, independence, and also adequate powers of investigation, pluralism, etc. The National Human Rights Commission's mandate covers both civil, political, as well as economic, social, cultural rights, and in that sense it has a wide mandate. In fact, the manner of appointment of chairperson and their service condition, the manner of their removal are such that they are required to maintain independence, exercise both functional autonomy, financial autonomy. The amount of money that is spent by NHRC is voted by the Parliament through some grants, and there is a body of personnel under the investigation division which is answerable only to the National Human Rights Commission, and the commission also, as we have earlier seen, has 6 members, of whom at least there shall be 1 woman member, and by virtue of the chairpersons of the National Commission for Women, Minorities, SCs, STs, children, and also backward classes, and also the Chief Commissioner for Persons with Disability being made as a deemed members of the NHRC, contributes towards the pluralism of the Commission. And so in a way, these elements go on to strengthen the Commission, but the civil society has its own reservation and wants it to be a more effective and robust body. The Act was initially adopted in the year 1993. It was amended once in 2006 and again recently in 2019, and with a view to making this further compliant with the Paris principles, with a view to making the body pluralistic, with a view to making it more effective. And the civil society, of course, is not fully happy or satisfied with the amendments that have been enacted in the year 2019. On the whole, here is an act which provides for the constitution of a national commission at the center, the state human rights commissions at the states, and also human rights courts, and they have all been, their functions, their powers, and then the procedures have all been mentioned in the Protection of Human Rights Act. See you in the next module. Happy learning.